Will the House please come to order and members can take their seats? Good afternoon. In lieu of a devotional today, will you please join me in a moment of silence? Members, we have 4 House bills for introduction today. The first is House Bill 486, which is an act relating to homestead declarations and property tax credit, introduced by Representative Christie of Shaftesbury. Please listen to the first reading of the bill.
486, an act relating to homestead declarations and the property tax credit.
For the first time, it is referred to the Committee on Ways and Means. Next is House Bill 487, which is an act relating to local option tax revenue sharing between a town and a village, introduced by Representatives Walker of Swanton and Oliver of Sheldon. Please listen to the first reading of the bill.
H487, an act relating to local option tax revenue sharing between a town and village.
And the first time, it is referred to the Committee on Ways and Means. Next is House Bill 488, which is an act relating to the fiscal year 2026 transportation program and miscellaneous changes to laws related to transportation, introduced by the Committee on Transportation. Please listen to the first reading of the bill.
H488, an act relating to the fiscal year 2026 transportation program and miscellaneous changes to laws related to transportation.
Now the bill has been read the first time and affecting the revenue of the state is referred to the Committee on Ways and Means pursuant to House Rule 35A. Finally, House Bill 489 is an act relating to fiscal year 2025 budget adjustments introduced by the Committee on Appropriations. Please listen to the first reading of the bill.
H489, an act relating to fiscal year 2025 budget adjustments.
Now the bill's been read the first time and affecting the revenue of the state is referred to the Committee on Ways and Means pursuant to House Rule 35A. Members, we also have one Senate bill for referral today. Senate Bill 44 is an act relating to authorization to enter into certain immigration agreements introduced by Senator White and others. Please listen to the first reading of the bill.
S44, an act relating to authorization to enter into certain immigration agreements.
Now the bill's been read the first time and is referred to the Committee on Judiciary. Members, earlier today, the Committee on Ways and Means voted out 3 bills that carry an appropriation and therefore are referred to the Committee on Appropriations pursuant to House Rule 35A, pending their entry on the notice calendar. The first is House Bill 397, which is an act relating to miscellaneous amendments to the statutes governing emergency management and flood response. Next is House Bill 472, which is an act relating to professions and occupations regulated by the Office of Professional Regulation. And finally, House Bill 479, which is an act related to housing. We now have a joint Senate resolution to take up at this time. JRS 18 is a joint resolution relating to weekend adjournment on March 21st, 2025. It was offered by Senator Baruth and was read and adopted on the part of the Senate. Please listen to the reading of the resolution.
Resolved by the Senate and House of Representatives that when the 2 houses adjourn on Friday, March 21st, 2025, it be to meet again no later than Tuesday, March 25th, 2025.
Now you've heard the reading of the resolution, and the question is, shall the House adopt the resolution in concurrence? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. Nay. The ayes appear to have it. The ayes do have it, and the resolution is adopted in concurrence. Members, we will now read a House concurrent resolution that the House and the Senate adopted pursuant to the consent calendar. HCR 13 is a House concurrent resolution in memory of the former esteemed clerk of the Vermont House of Representatives, Robert Louis Piche of Winooski. Please listen to the reading of the resolution.
Whereas dispassionate, informed, and nonpartisan are all essential attributes for the Clerk of the House of Representatives. And for 3 decades in this role, from 1963 to 1993, and again in 2002 on an acting basis, House Clerk Bob Piche, Mr. Piche, always adhered to these core principles, as was reflected in his election during the 1980s as President of the American Society of Legislative Clerks and Secretaries. And whereas Mr. Piche, a lifelong resident of Winooski, was born on July 30th, 1924, and graduated from the former Cathedral High School in Burlington, Assumption College in Worcester, Massachusetts, and Georgetown University Law School in Washington, D.C. And whereas he served in Europe as a World War II U.S. Army combat platoon leader, returned to active duty during the Korean conflict, achieved the rank of Lieutenant Colonel in the Vermont National Guard, and was the commander of and a Major General in the Vermont State Guard. And whereas a respected lawyer, Mr. Piche was an extraordinary public servant who, prior to his election as Clerk of the House, served as executive clerk to Governor Joseph B. Johnson and as Secretary of Civil and Military Affairs under Governor Robert T. Stafford. And whereas locally, he was elected as a zoning board member, a justice of the peace, and grand juror. And whereas Mr. Piche's religious and musical passions found commonality as a parishioner, chorister, and choral director at St. Francis Xavier Church. He also sang in the South Burlington Community Chorus, and he enjoyed other voluntary roles related to his French-Canadian heritage, Veterans Affairs, and the Winooski community's history. And whereas Mr. Piche died on May 10th, 2024 at 99 years of age, and his survivors include his children, grandchildren, and great-grandchildren. Now therefore, be it resolved by the Senate and House of Representatives that the General Assembly extends its sincere condolences to the family of the former esteemed clerk of the Vermont House of Representatives, Mr. Robert Louis Piche. And be it further resolved that the Secretary of State be directed to send a copy of this resolution to the family of Mr. Bob Piche.
Are there any announcements? Member from Williston.
Thank you, Madam Speaker. I am thrilled to introduce some guests today. Though they are not constituents from my community, they are all of our constituents and my favorite type, young people doing amazing things. I'd like to welcome Habitat for Aviation, which is a youth apprenticeship training program at the Franklin County Airport in Swanton, working to prepare the next generation of airplane mechanics, aviation specialists, and pilots. The vision of their program is to serve as a strong model for learning through relationships, relevance, and practice. They value the trusted relationships, teamwork, and meaningful, relevant work with each other every Sunday as they are literally building an airplane. Please welcome the guests in fabulous pink overalls up in the gallery.
Will the guest, the member from Williston, please rise and be recognized? Are there any further announcements? Member from Springfield.
Madam Speaker, I'd like to say a few words on the resolution honoring our former clerk, Bob Piche. I had the distinct pleasure of working with Mr. Piche when I was a freshman back in 1982, when I was a lot younger than I am now and very naive. And I'll share some of that with you shortly. But with us today, live streaming, not here personally, are some family and friends of Mr. Piche, and they're watching live stream to hear the resolution, as well as his longtime journal clerk, Sandra Collins, who served in the House Clerk's office for over 2 decades. And hopefully, Mr. Piche's son, who lives in Boston, may also be live streaming. So I'd like to recognize them and thank them for sharing this with us today. When I first came in here in 1982, we have a general idea of what the legislative branch does and how the House functions. And Madam Speaker, Mr. Pichet brought everyone, each and every one of us, the 150 members, under his wing to really teach us how to be legislators. He taught us the value of this General Assembly, the value of the House of Representatives, and the value of each and every one of us as members. And he also taught us how legislation works, how it goes through this body. But he particularly focused on the decorum of this General Assembly and this chamber. And I learned everything I've learned today about the legislative process and the decorum of how we operate as members of the General Assembly in this body. And I have tremendous respect for Mr. Pichet, and I want to thank him and his family and members that supported him throughout his time here in this chamber. The resolution started where Mr. Pichet was dispassionate, informed, and nonpartisan in all of the essential attributes of the clerk. And he adhered to those principles, and he did. And he instilled those principles in each and every one of us. And one of the best ways that he did it, that I remember the best, he always had a story. He always had a sense of humor. He always had a joke about what transpired on the floor of the House. And we learned how to operate in this building. And we learned the decorum of this General Assembly through those jokes and through those stories of previous members and how they interacted on the floor. And I'm going to say a word that maybe some folks don't like to hear, but I'm going to say it. Mr. Pichet was a gentleman. And I thank him and his family for sharing that with us. Thank you.
Will members please join me in recognizing the former clerk's family? Member from Enosburg.
Thank you, Madam Speaker. I know we just recognized a group of special young ladies from Habitat for Aviation, but I would like to at least mention one. This young lady is a senior at BFA St. Albans. She's presently pursuing her pilot license and will be attending Florida Tech this fall. But she happens to be my granddaughter, Abby.
Will
I'd like to recognize her.
Member from Winooski.
Madam Speaker, I move that the remarks by the member from Springfield be journalized.
The member from Winooski moves that the remarks from the member from Springfield be journalized. Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have journalized the remarks of the member from Springfield. Member from Fairfax.
Thank you, Madam Speaker. I stand because I have strict orders from the member in Chittenden to let the body know that if you are participating in March Madness, that the men's bracket deadline is tomorrow at noon, while the women's bracket deadline is Friday at 11:30. So if you miss the deadline, too bad, so sad. We'll still keep your $5 and consider it donation.
Are there any further announcements? Member from Brattleboro.
Thank you, Madam Speaker. This is a reminder that the Climate Solutions Caucus will meet tomorrow at noon in room 10. There will be pizza, and we will be hearing from the state treasurer about their work on the Climate Superfund. Anybody is welcome.
Are there any further announcements? Member from Burlington.
Madam Speaker, I have a guest today in the House, and I hope you will help me welcome him to the People's House. His name is Tory. Tory became homeless due to a severe rent increase. He was born in Berlin, Vermont, and has worked full-time his entire life, even as he has faced homelessness. He depends on supplemental oxygen to survive. He is constantly looking for housing, engages with supports and services, but so far has found nowhere to call home. Because Tory has nowhere to go, so if nothing changes, he will be forced to live outside on April 1st, losing access to the oxygen he needs to survive. Will my fellow members please join me in welcoming this lifelong Vermonter to the chamber today?
Will the guest and the member from Burlington please rise and be recognized? Member from Westminster.
Thank you, Madam Speaker. Today, I also have a guest. I would like members to join me in welcoming my guest, Cynthia, and her service dog, Dixie May. Cynthia lost her housing due to a disability. Cynthia has been working to apply for every possible housing unit, but thus far has not found it. She has complex medical needs and challenges to accessing housing. So far, she has not had any positive outcomes in terms of finding new possibilities. If nothing changes, Cynthia will reach her 80-day cap this spring with no other options. She will have no choice but to move outside. Members, can you please join me in commending the courage that Cynthia faces every day?
Will the guest and the member from Westminster please rise and be recognized? Member from Hartford.
Thank you, Madam Speaker. I too have a guest with me today in the balcony, another lifelong Vermonter, Donna Jo. Donna Jo and her mother lost their housing due to no cause. Donna Jo cares for and lives with her mother, who could not be here today because she is bedridden. Her mom has tumors throughout her body and herself requires electricity for her breathing device. Donna and her mother have applied for every available apartment, but so far have not found one. Without another option, if nothing changes, Donna Jo and her bedridden mother will have to somehow try to survive outside. Donna Jo, like so many other Vermonters, is caretaking another family member, but in circumstances most of us could never imagine. Will members please join me in warmly welcoming this person of great courage to the chamber today?
Will the guest and member from Hartford please rise and be recognized? Member from Westminster.
Thank you, Madam Speaker.
West Windsor, I apologize.
I also have a guest here among us today, and he's sitting in the balcony, and his name is David. And he's a fine gentleman. David was born and raised in Barrie, and but recently, the home where he was living with his family burned down, and so David has had cognitive and physical disabilities all of his life. The physical ones, which require electricity to support him. He's been on every wait list possible, but the wait list for housing, or the list of available housing for people with disabilities is very, 0.04%. So not very many available. So David has been on every waiting list possible and has not been able to find anything. He is also among the individuals who would be forced to sleep outside starting in April because there's no other place for him to go. Please join me in honoring David's strength and welcoming him to the People's House.
Will the guest and the member from Westminster please rise and be recognized? Member from Bristol.
Madam Speaker, today I want to welcome my guest, Heidi. Heidi lost her housing due to no-cause eviction. She lives with disabilities and suffers multiple seizures every day, along with chronic lung disease, emphysema. Traditional shelter is not an option for her because it is not medically safe. Heidi has several service supports, medical providers, and disability services, and has done everything she can to look for housing, but so far has come up short. Without other options and nowhere to go, Heidi will be forced to live outside with her disabilities come April 1st if nothing changes. Heidi faces challenges every day that most of us cannot imagine. I invite the members to join me in commending Heidi for her strength and resolve today.
Will the guest and member from Bristol please rise and be recognized? Member from Montpelier.
Madam Speaker, I have a special guest today. His name is Jerome, my friend. Jerome became homeless after his wife died. They had moved to Brandon and she passed away during the pandemic. He's an Army guy, but this situation cut his income right in half. Just 2 weeks afterwards, Jerome had to have spinal surgery, which essentially just eliminated all his income. He today lives with significant physical disabilities, and he's losing his eyesight. He has insulin-dependent diabetes, and his medicine needs to be refrigerated at all times. He's applied for every available apartment, but there's just nowhere to go. And if nothing changes on April 1st, Jerome's going to be forced to live outside with his disabilities, trying to find insulin. He's been through the mill, but I just want to say Jerome's shown incredible courage through unbelievably challenging circumstances. And I'd really invite the body to welcome him here today.
Will the guest and member from Montpelier please rise and be recognized? Member from Wolcott.
Thank you, Madam Speaker. Just over a year ago, Vermont launched Age Strong Vermont, our multi-sector plan on aging, a bold 10-year blueprint designed to improve the lives of older Vermonters. This initiative addressed key challenges including affordability, housing, health services, transportation, ensuring that our communities remain livable and inclusive for all generations. Older Vermonters are the backbone of our state. Their wisdom, experience, and deep commitment to community strengthen Vermont in countless ways, whether through volunteerism, family support, unpaid caregiving, or economic contributions. They play a vital role in shaping our state's present and future. Did you know that Vermont leads the nation in labor force participating among older adults? Their skills and experience help reduce workforce shortages and keep our economy strong. 40% of unpaid caregivers in our state are older adults, saving our health system millions of dollars annually. 35% of Vermonters aged 65 and older volunteer their time serving on boards, providing transportation to medical appointments, offering companionship and delivering Meals on Wheels, and assisting with everyday tasks. Let's not forget their economic contributions through lifelong of taxes, spending power, and intergenerational financial support. Older Vermonters boost local businesses, assist younger generations, and keep families connected. By 2030, 1 in 3 Vermonters will be over the age of 60. This demographic shift presents both challenges and incredible opportunities. By investing in age-friendly communities, we can support the health and independence and well-being of older Vermonters while driving economic growth and innovation. Together, we can build Vermont that is a truly age-strong. Today, I ask my colleagues to recognize and honor the contribution of older Vermonters. Let us continue to support efforts led by the Vermont Department of Disabilities, Aging and Independent Living, Department of Health, our area agencies on aging, the Alzheimer's Association, AARP, SASH, and programs like Meals on Wheels. Organizations dedicated to ensuring that every Vermonter can age with dignity in their community. Please welcome them to the People's House. They are seated in the gallery.
Will the guests of the member from Wolcott please rise and be recognized? Member for Middlebury.
Madam Speaker, it's my pleasure this afternoon to introduce to you and through you Peter Brewitt and his Ecological Restoration Politics class, which is a senior level class at the Rubenstein School of Environment and Natural Resources. Please welcome them. They're seated in the gallery.
Will the guests of the member for Middlebury please rise and be recognized? Are there any further announcements? Seeing none, orders of the day. Members, we have one adjustment to the calendar in the order of bills this morning. House Bill 243, which is the regulation of business organizations. It can be found on the second page of our booklet today. We will move that up to be the first bill we take up and then go back to the order of bills. With that, we're going to start with House Bill 243, which is an act relating to the regulation of business organizations. The bill is referred to the Committee on Commerce and Economic Development, which recommends that the bill be amended as printed in today's calendar. The member from Pownell, Representative Cooper, will speak for the committee. And affecting the revenue of the state, the bill was then referred to the Committee on Ways and Means, which recommends that the report of the Committee on Commerce and Economic Development be amended as printed in today's calendar. The member from South Burlington, Representative Burkhart, will speak for that committee. Please listen to the second reading of the bill.
H 243, an act relating to the regulation of business organizations.
Member from Pownell.
Madam Speaker, House Bill 243 is an act relating to the regulation of business organizations. It is my pleasure to walk you and all present through this important bill, which can be found in today's House calendar on page 718 and just about every other page in the calendar today. But a bit of table setting, the Business Services Division of the Secretary of State's office is behind nearly every bit of private sector commerce we transact, because every business entity in Vermont is required to have a relationship with the Secretary of State. When the Fourth Estate, law enforcement, public officials, private citizens, or nosy economic development planners want to know who actually owns that new business in town or who's involved with the business entity that just acquired an old mill, the Secretary of State's office is the authoritative source. Ensuring that the information is true and up to date is a matter of public interest. The statutory changes within the bill fall into three categories. First is a series of changes to the many statutes governing business formations, amendments, and filings in an effort to standardize and equalize the process across business organization types. Second, there's a modification to the powers of the Secretary of State's office to allow for the use of enhanced discretion in the realm of ministerial law. And then finally, to ensure that a study is conducted in the months to come that will address outstanding questions and issues pertinent to business regulation, including potential adjustments to the associated filing fees collected by the division in the discharge of its duties. As fees are not the remit of your Committee on Commerce and Economic Development, this is the last I'll mention of that term, and I look forward to the subsequent report from the member from South Burlington. H 243 includes several revisions to Titles 11, 11A, 11B, and 11C, which do the following: make technical corrections, harmonize terms, eliminate redundancies, and add new language intended to help prevent fraudulent business filings with the Secretary of State's office. Sections 1 through 7 of the bill mostly pertain to Title 11 amendments. And Title 11 governs Vermont corporations, partnerships, and associations. For example, the title of Chapter 7 is changed from cooperatives to general cooperative corporations and cooperative associations. Instances of the term corporation are changed to association to update with the terminology now used at the Secretary's office. There are also instances of corporations used throughout Title 11 that are updated to the term business organizations in order to recognize those other forms of businesses. The proposal adds a new section in 11 VSA 1638, which adds administrative authority of two kinds that are not currently available to the Secretary of State. First, to reject a record that contains false, fraudulent, or clearly erroneous information. And second, to amend a record or terminate registration after notice and opportunity for hearing under the Vermont Administrative Procedure Act if a person has submitted false or fraudulent information in a record, or submitted a record for filing in bad faith without lawful authority or to commit fraud or cause injury. A person aggrieved by the Secretary's decision under this section may appeal de novo to the Civil Division of the Washington Superior Court. There is a firm rationale for creating this authority, Madam Speaker. Businesses can be affected by amendments submitted without legal authority. Individuals can be affected by fraudulent use of valid physical or mailing addresses. And initial filings with clearly erroneous information, such as an address in a town that does not exist in Vermont, are problematic entries into the public record. To add context, there is a nationwide rise in fraudulent business filings that use the address of an unsuspecting property owner, and this is also occurring in Vermont. An individual living at such an address begins to receive correspondence addressed to the business, promotional materials, notices from creditors, documents from the Secretary of State itself, and a litany of other written communications, and is further frustrated to find that the Secretary of State does not have clear express authority to resolve the matter. Just as alarming, the Secretary of State's office is then holding a business record in a publicly searchable database that is known to contain falsified information. It is essential that the Secretary of State provide relief to those affected by the activities of bad actors, as well as ensure the public trust in the Secretary's business records. The Secretary's office is also given the authority in 11 VSA 1639 to adopt forms, procedures, and rules to implement the process and provisions of governing business registration in the state. Now, this authority is currently available to the Secretary in other business organization statutes, but not for registration. Section 1655 harmonizes the agent for service of process provisions, which is cross-referenced throughout the title. And for those unfamiliar with the term, an agent for service of process is the person designated by a business entity to receive legal documents on its behalf. Several instances of the procedure for using an agent for service of process are updated in this bill, requiring a business to include its principal office address and the name, address, and email of its agent for service of process. Sections 8 through 24 of the bill reflect technical changes to harmonize agent for service of process provisions and to update language to match current terminology used by the Secretary of State's office. Sections 8 through 14 amend Title 11A, which governs Vermont business corporations. Sections 15 through 21 amend Title 11B, which governs Vermont nonprofit corporations. And sections 22 through 24 amend Title 11C, which governs Vermont mutual benefit enterprises. Sections 25 and 26 amend Titles 12 and 30, respectively, and are again making technical changes based on other changes being made in the bill. Finally, Section 27 creates a study for the Secretary of State's office to conduct. The Secretary is required to engage with interested partners to evaluate the following: issues concerning the online business filing system, statutory revisions to adopt provisions of the Uniform Business Organizations Code, laws governing trademarks, the amount of fees collected for various business filings, and assessing the oversight authority for data brokers, telemarketers, and utility cooperatives. If passed, the bill is effective on July 1st, 2025. Madam Speaker, in taking testimony on H243, we heard from Legislative Counsel, from the Office of Legislative Counsel, and the Director of Business Services in the Secretary of State's office. The bill was taken up by your Committee on Commerce and Economic Development in mid-February and voted out of committee as favorable with amendment by a vote of 11-0-0 on March 12, 2025, and we ask for your support.
And now speaking for the Committee on Ways and Means, member from South Burlington.
Thank you, Madam Speaker. H243 was referred to your Committee on Ways and Means because it delineates the different types of fees paid by business organizations to the Secretary of State for activities such as registration, renewal of business licenses, filing of reports, amendments to filings, and other activities related to the state's regulation of business organizations. In current statute, different types of organizations may pay different fees for the same activity, even though the activity creates the same administrative burden on the Secretary of State. A single type of organization may pay different fees for different activities that create very similar workloads for the Secretary of State. Your Committee on Ways and Means was asked to review, standardize, and simplify the many fees covered by H.243. When we propose changes to fees, we like to have data that will help us predict the overall impact of the changes on the state's revenue. We especially like to see trends over time about which fees are increasing in utilization and which ones are decreasing. Typically, this data is provided to the Joint Fiscal Office, and they produce a fiscal note to help us in our work. We had testimony from the Secretary of State that until their new information system was implemented just a couple of months ago, they did not have the ability to provide the kind of data we need. We understand that their new information system will allow them to provide the kind of information we could use to make better recommendations about changes to fees related to the regulation of business organizations. However, the system has not been in place long enough to provide good data about trends. Because we'll have much better information in several months, your Committee on Ways and Means determined that it would be best to leave the fee structure in current statute unchanged for the time being and potentially revisit it when better information is available from the Secretary of State. Specifically, our amendment to the bill did two things. First, the Committee on Commerce and Economic Development had proposed striking several sections of statute relating to fees and replacing them with references to a new fee schedule. The Committee on Ways and Means asked that those sections be put back into the existing language. And you will see an example of one of these changes if you compare section 997 of the bill that starts on page 723. That is the version that came from Commerce and Economic Development to our committee, with the same section 997 that is on page 793 of today's calendar. And that is our proposed amended version. Second, we added the fees collected for various business organization filings be added to the scope of work of the business organization study that my colleague from Pownell just mentioned, that is proposed at the end of the bill. We heard from the following witnesses: Director of Business Services, Secretary of State's Office; Legislative Counsel, Office of the Legislative Counsel. And the vote on this bill as amended by our committee was 11-0-0, and we recommend that it ought to be passed as amended. Thank you, Madam Speaker.
Member from Pownell.
Madam Speaker, a March 18th straw poll of the committee supported the amendment proposed by the Committee on Ways and Means 10-0-1.
Now the member from South Burlington, Representative Burkhart, and the member from Pownell, Representative Cooper, will offer an amendment to the report of the Committee on Ways and Means. The first assistant clerk emailed this amendment to members at 10:22 today. This amendment also appears on the House Overview webpage, and copies are available at the main table. Member from South Burlington.
Thank you, Madam Speaker. After the Committee on Ways and Means voted favorably on our amendment to H.243, the need for a technical correction was noted. If you turn to page 737 in today's calendar, you will note that sections 1655 and 1656, both titled Secretary of State as Agent for Service of Process, are very similar to one another. There was a small section added to 1656 that delineates deadlines and timing of serving of process more clearly than it had been delineated in 1655. Section 1656 was meant to entirely replace Section 1655, but Section 1655 was not deleted. We propose that we amend the bill to remove Section 1655. We took testimony from Legislative Counsel, Office of Legislative Counsel, and then held a straw poll this morning that was an 11-0-0 vote to recommend that the bill be amended further for this technical correction.
Member from Pownell.
Madam Speaker, the Committee on Commerce and Economic Development took a straw poll on this amendment, the vote of 10-0-1 earlier today.
So the question is, shall the report of the Committee on Ways and Means be amended as offered by the member from South Burlington and the member from Pownell? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have amended the report of the Committee on Ways and Means. Now the question is, shall the report of the Committee Committee on Commerce and Economic Development be amended as recommended by the Committee on Ways and Means as amended. Are you ready for that question? Member from Northfield.
Madam Speaker, I have a brief question that's probably technical in nature, if I may inquire of the member from Pownell.
The member from Pownell is interrogated.
Madam Speaker, this is language that was both in the original and amended bill, and I've marked both sections. I don't know if it'd be easier for the member for me to refer to the page numbers of the Ways and Means Amendment or the page numbers of the bill as he reported it.
Perhaps Ways and Means?
Thank you, Madam Speaker. So turning to page 804 of today's calendar, this question's in regards to reserved names. And I'm wondering why that name can only be reserved exclusively for 121 days. I noted in contrast that in two other sections on page 810 and on page 830 that corporations and associations can each seek to reserve a business name simply by delivering an application. But this seems to restrict the ability to retain it for 120 days, which is my question. Thank you, Madam Speaker.
May I ask for a recess to understand this question better?
The House will stand in a brief recess while the member consults Legislative Counsel. Will the House please come to order and members kindly take their seats? Will the House please come to order? Member from Pownell.
I am glad to add a little bit of clarity to section 1652 in subchapter 3 about the administrative provisions for business organizations. The reserved name detailed there in section A, where the secretary shall reserve the name for the applicant's exclusive use for 120 days, pertains explicitly and exclusively to individuals who have not yet begun an application for business registration but would like to hold a name in reserve while they undergo that process.
Madam Speaker, that makes perfect sense, and I appreciate the explanation.
So the question is, shall the report of the Committee on Commerce and Economic Development be amended as recommended by the Committee on Ways and Means as amended? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have amended the report of the Committee on Commerce and Economic Development. Now the question is, shall the bill be amended as recommended by the Committee on Commerce and Economic Development as amended? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have amended the bill. Now the question is, shall the bill be read a third time? Are you ready for that question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and third reading is ordered. Now we'll turn to House Bill 222, which is an act relating to participation in a domestic violence accountability program as a condition of a final relief from abuse order. The bill was referred to the Committee on Judiciary, which recommends that the bill be amended as printed in today's calendar. The member from Williston, Representative Arsenault, will speak for the committee. Please listen to the second reading of the bill.
H222. An act relating to participation in a domestic violence accountability program as a condition of a final relief from abuse prevention order.
Member from Williston.
Thank you, Madam Speaker. I will be utilizing a throat lozenge, and I trust it will grow less distracting as it decreases in size. H222 can be found on page 704 of today's calendar. H222 revises Vermont's Civil Protection Order statutes to provide better relief to victims of domestic violence, sexual violence, and stalking. Protection orders are a critical legal tool for victims. They are civil court orders requested directly by a victim plaintiff. If granted, the orders offer important protective measures to prevent future harm, including requiring a perpetrator of violence to maintain physical distance from a survivor. There are separate protection order statutes for victims of domestic violence and victims of sexual assault and stalking. H222 impacts both in different ways. First, it revises Vermont's civil stalking order to better capture device-related stalking. The definition of stalking in Vermont's Civil Stalking Protection Order statute requires a course of conduct, meaning 2 or more acts over a period of time, no matter how short, to meet the threshold for a protection order. Service providers have found that it can be challenging to apply this definition in cases of device-related stalking. For example, when a device like an AirTag or a tracking app is placed once and then used to continuously surveil, there has been confusion in the courts regarding whether those activities meet the definition of course of conduct. This has left victims of serious device-related stalking without the protective measures they need. Second, H222 adds temporary possession of a vehicle to the forms of available relief listed in the Domestic Violence Relief from Abuse Order statute. There are a number of explicitly stated forms of relief available to victims, including primary possession of a residence, pets, or custody of shared children. However, current statute does not explicitly list primary possession of a vehicle as a form of relief. It's important to add this because a vehicle can be a lifeline when escaping violence and leading an independent life immediately afterwards. Finally, H222 adds completion of a domestic violence accountability program to the forms of available relief listed in the Domestic Violence Relief from Abuse Order statute. I will refer to the resulting order as an RFA. This suggestion came directly from the 2025 report offered by Vermont's Domestic Violence Fatality Review Commission. Domestic violence accountability programs, commonly referred to as DVAPs, are community-based treatment programs designed to address the needs of people who use violence in their intimate partner relationships. DVAPs acknowledge that abusive partners are, in most cases, capable of change and seek to modify behaviors and develop skills to prevent future abuse. It would be helpful here to explain a little more about the relief from abuse process. As I mentioned previously, when applying for a relief from abuse order, victim plaintiffs can request various forms of relief to keep themselves and their loved ones safe. A large number of victims pursue civil protection orders, but not a parallel criminal process. There are many reasons for this, including the emotionally or financially taxing nature of a criminal case. Currently, it is only through that criminal process that a defendant can be required to participate in a DVAP as a condition of probation. This leaves a significant gap in the referral pathway to DVAP. It is unlikely that a survivor's current or former partner will be referred to DVAP without a criminal process, even if that's what the survivor wants. Many victims report that an accountability program to change behavior would be extremely helpful as part of a civil protection order. Victims may want to reduce the risk of violence for their shared children, a future partner, or themselves if they hope to maintain the relationship. H222 expands options for victims and the courts and supports people who cause harm in accessing services to change their behavior, leading to a better and safer life for themselves and others. Vermont has 12 community-based DVAPs that offer in-depth group programming and are certified by the Vermont Council on Domestic Violence. While DVAPs are not the sole vehicle for holding abusive partners accountable or changing behavior, they are a critical component to our response to domestic violence and can improve outcomes for both victims and people who use violence. With that overview as background, we'll now dive into the bill section by section. Section 1 amends the definition of course of conduct to specifically include behavior conducted through the use of technology. The new language reads as follows: use of any electronic, digital, or precise geolocation device or software or application to surveil a specific person or a specific person's internet or wireless activity continuously for 12 hours or more, or on 2 or more occasions over a period of time, however short, without authorization. Section 2 is an amendment to the statute governing the issuance of final relief from abuse orders. Again, these are civil orders of protection involving family or household members and are issued if the court finds that the defendant has abused the plaintiff and A, there is a danger of further abuse, or B, the defendant is currently incarcerated and has been convicted of specific crimes such as murder, kidnapping, or sexual assault. Subdivision C2 lists the various orders a court can make to protect the plaintiff, including directing the defendant to stay away from the plaintiff, awarding possession of a shared residence to the plaintiff, and making arrangements for the care, custody, and control of any children in the household. The amendment adds language in subdivision C2I that permits a court to award temporary possession of a vehicle to the plaintiff, provided first, the plaintiff is the owner or joint owner of the vehicle. The plaintiff is the primary payer on the vehicle loan, the plaintiff has primary possession or control of the vehicle already, or the plaintiff has been restricted from using the vehicle by the defendant. In subdivision C2J, the amendment permits the court to require the defendant to complete a domestic violence accountability program approved by the Council on Domestic Violence. Usually, a violation of the conditions of the abuse prevention order are considered a misdemeanor under 13 VSA 1030. However, for this condition only, failure to comply will not be a crime, but the defendant may be subject to civil contempt proceedings. Successful completion of the program shall be considered a substantial change in circumstances for purposes of request to modify, possibly shorten, a protection order. A court may consider a defendant's failure to successfully complete the program when determining whether to extend an order. These types of orders are usually in effect for a year but may be extended. Section 3 pertains to temporary emergency orders of protection. These orders are in effect for only 10 days, upon which time a hearing is held to determine whether to issue a final order pursuant to Section 3 of this bill. The amendment in Section 3 provides the court with the ability to award temporary possession of a vehicle to the plaintiff, but because the order is an emergency ex parte order, meaning issued without the defendant notified or present, there is an additional requirement that the court finds that awarding possession of the vehicle to the plaintiff is necessary for the plaintiff to escape abuse or prevent further abuse. This follows similar language in existing statute regarding possession of the residence, which requires a higher standard for the temporary order versus the final order because of the ex parte nature of the temporary order. Section 4 requires that the Domestic Violence Fatality Review Commission report in its biennial findings and recommendations on the number of defendants ordered to complete a domestic violence accountability program approved by the Council on Domestic Violence pursuant to Section 2 of the bill, as well as the number of those defendants who completed the program. Section 5 is the effective date, July 1, 2025. Madam Speaker, we must always remember that one of the biggest threats to public safety in Vermont is domestic violence. Between 1994 and 2023, 44% of all homicides in Vermont were related to domestic violence. The Domestic Violence Fatality Review Commission is charged with the grim but essential task of examining domestic violence-related deaths and to recommend policy changes to help prevent such deaths from happening in the first place. Their recommendation of adding participation in domestic violence accountability programming as a condition in a civil protection order is an important step further in the direction of actual prevention. Because we know that many abusers will go on to hurt more people and that without help, their violence may escalate. We also know that as technology evolves, our laws must evolve with it. H222 adds a definition of device-related stalking to the relevant statute to close an existing gap and clear up any confusion, again, increasing the effectiveness of Vermont's protection orders. And lastly, H222 contains a provision that recognizes the importance of reliable access to a vehicle when a survivor is trying to reach safety. This is yet another way that we, as a state, through our courts, can provide the precise forms of relief that victims need. Let's vote in favor of saving lives and holding people accountable by supporting H222. House Judiciary heard from the following witnesses: Victims' Rights Project Director at Vermont Legal Aid, Legislative Counsel from the Office of Legislative Counsel, the Director of Policy and Legislative Affairs with the Attorney General's Office, Director of Policy from the Vermont Network Against Domestic and Sexual Violence, Assistant Attorney General and member of the Domestic Violence Fatality Review Commission, Co-Director of the Vermont Council on Domestic Violence, Deputy Director of Field Services from the Department of Corrections, Legislative Attorney for the Vermont Department of State's Attorneys and Sheriffs, the Director of a Domestic Violence Accountability Program, and the Chief Superior Judge for the Vermont Judiciary. Our committee vote was 9-0-2, and we ask for your support.
The question is, shall the bill be amended as recommended by the Committee on Judiciary? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have amended the bill. Now the question is, shall the bill be read a third time? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and third reading is ordered. Next is House Bill 125, which is an act relating to reporting on the energy transition. Please listen to the third reading of the bill.
H 125, an act relating to reporting on the energy transition.
The question is, shall the bill pass? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. Nay. The ayes appear to have it. The ayes do have it, and you have passed the bill. Next is House Bill 231, which is an act relating to technical corrections to fish and wildlife statutes. Prior to third reading, the member from Randolph, Representative Sakowicz, and others offer an amendment that is printed in today's calendar. Member from Randolph.
Madam Speaker, the House Environment Committee heard the concerns expressed yesterday about some of the language contained in Section 4 of the bill. In response, we amended the bill. You may find the amendment on page 710 of today's calendar. The amendment removes Section 4 of the bill. All 11 members of the committee appear as sponsors of the amendment, and we request your support of the bill as amended.
The question is, shall the bill be amended as offered by the member from Randolph and others? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have amended the bill. Please listen to the third reading of the bill.
H 231, an act relating to technical corrections to fish and wildlife statutes.
The question is, shall the bill pass? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have passed the bill. Next is House Bill 259, which is an act relating to preventing workplace violence in hospitals. Prior to third reading, the member from Bristol, Representative Cordes, offers an amendment that is printed in today's calendar. Member from Bristol.
Thank you, Madam Speaker. House Healthcare Committee thanks the member that brought the concerns of H259 to us. And we spoke with advocates and with the member and developed this amendment with unanimous support from all involved. The first instant of amendment addresses the section that where the security plan, the hospital security plan, must prioritize the safety and retention of hospital employees. And it was never the intent of the bill to have the prioritization of healthcare workers over patients. But this amendment clarifies that, and that we continue to support patient rights around this issue of workplace violence. And so we added to the section that says prioritize the safety and retention of hospital employees, and added to the extent permitted under state and federal law. The second instant of amendment, the member was correct. There was an incorrect cross-reference to statute, and it's not necessary actually to have a cross-reference there, so we just removed it. So we're striking pursuant to 18 VSA Chapter 1883. And the third instance of amendment, this addresses in the, there's a section of the bill where the hospitals in their filings with the Green Mountain Care Board for the hospital budget review will add to their filing information any costs associated with the workplace violence prevention plan and the subsequent annual evaluation and the data collection. And so the intent of this was to make sure that when the Green Mountain Care Board was considering that particular hospital's budget, they were taking into consideration the costs, any costs that the hospitals incurred toward these hospital workplace violence protection programs. So the intent was to help hospitals to make sure that it's clear that, and the entirety of the bill really is about developing a plan, analyzing data, and annually updating the plan, training employees. There's nothing in the bill that states that hospitals must make capital investments, but to be clear about that, we've added the third instance of amendment. Nothing in this section shall require a hospital to make capital investments to implement its security plan. Again, we talked with the advocates that helped develop H259, and everyone was in agreement. We worked with the member, everyone was in agreement with these changes, and we hope that you'll support H259 as amended.
The question is, shall the bill be amended as offered by the member from Bristol, member from Northfield?
Madam Speaker, if I may just return the appreciation for the good work and collaborative work on these amendments.
The question is, shall the bill be amended as offered by the member from Bristol? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have amended the bill. Please listen to the third reading of the bill.
H259, an act relating to preventing workplace violence in hospitals.
The question is, shall the bill pass? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have passed the bill. Next is House Bill 396, which is an act relating to the creation of the Molly Beatty Distinguished Service Award. Please listen to the third reading of the bill.
H396, an act relating to the creation of the Molly Beatty Distinguished Service Award.
The question is, shall the bill pass? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have passed the bill. Next is House Bill 474, which is an act relating to miscellaneous changes in election law. Member from Vergennes.
Thank you, Madam Speaker. Your House Committee on Government Operations and Military Affairs moves that we delay action on H474 for one legislative day.
The member from Vergennes moves to postpone action on House Bill 474 for one legislative day. Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have postponed action on House Bill 474 for one legislative day. Now we'll turn to House Bill 80, which is an act relating to the Office of the Healthcare Advocate. The bill was referred to the Committee on Healthcare, which recommends that the bill be amended as printed in today's calendar. The member from Colchester, Representative Critchlow, will speak for the committee. Please listen to the second reading of the bill.
H80, an act relating to the Office of the Healthcare Advocate.
member from Colchester.
Thank you, Madam Speaker. H80 is an act relating to the Office of the Healthcare Advocate, HCA. The committee vote was 10-0-1 in favor of H80. The Healthcare Advocate is an important resource for Vermonters. They run a helpline that is available to anyone who calls Vermont home. The Healthcare Advocate is there to help Vermonters who are experiencing barriers that interfere with them getting the care that they need. When we can, it's always important to turn to real Vermonters' voices. May I quote a Vermonter?
You may.
Quote, if every company out there had employees like my Healthcare Advocate, the world would be a much better place. She went out of her way to help me receive all of the help that I should have been receiving. She took a very long time to explain and be sure I understood all the aspects of my case. If not for her, I would not have the health care that I deserve and was entitled to, end quote. And on a personal note and a professional note, as both an elder care case manager and as a fair hearing specialist, when the ACA first rolled out with its numerous challenges, I regularly referred clients to Vermont Legal Aid, knowing they would receive the help they needed, navigating the complex issues associated with both care and coverage in our healthcare system. Their value to Vermonters cannot be understated. I am pleased to bring you H80, which will bring our state law up to date with the practices and activities of the Office of the Healthcare Advocate. The Office of the Healthcare Advocate, formerly known as the Healthcare Ombudsman, was originally framed up in statute in 1998. Through an RFP process, it started operations as Vermont Legal Aid in 1999 and has been housed there ever since. In 2013, the office name was changed to the Healthcare Advocate and its duties were significantly expanded. Since its inception, the office has served about 70,000 Vermonters through its helpline and has worked on most of the state's major healthcare policy initiatives and reform efforts. When a constituent comes to me with a concern about access to healthcare, I am grateful to have the resource of the Healthcare Advocate. I'm sure many of you have turned to them too with some of your constituents. We have not updated the HCA statute since 2013. Now I will walk you through H80 and your Healthcare Committee amendment. Section 1 updates the health insurance rate review section of the statute to strengthen the Healthcare Advocate's right to ask questions of health insurers in the Green Mountain Care Board's rate review process. The Healthcare Committee amended in its first instance has an adjustment to that language. In a few minutes, the member from Essex and all members of the Healthcare Committee will offer an amendment to update this language. Section 2 clarifies the role of the Healthcare Advocate and the Long-Term Care Ombudsman's Office, also at Vermont Legal Aid, and a review certificate of need applications by the Green Mountain Care Board, including the right to receive confidential information in the proceedings. Section 3, this section really is the heart of the bill. It comprehensively updates Title 18, Chapter 229 of the Vermont statutes, the chapter that creates the Healthcare Advocate and describes the office work on behalf of Vermonters in its relationship to state government. The updates bring the Healthcare Advocate statutes into line with current practice and reflects how the office has grown into its role as an independent advocate for Vermonters in matters related to the healthcare access and affordability. The Healthcare Advocate does more than help Vermonters with healthcare issues. Health insurance issues. The office helps Vermonters with access to care issues and helps Vermonters find ways to make their care affordable. The office helps Vermonters to understand their rights under all kinds of state and federal laws and regulations related to health care. And the office is the voice of Vermonters on healthcare matters before not just the Green Mountain Care Board, but also the Department of Financial Regulation and other state agencies impacting healthcare. Because as a state, we have come to rely on the healthcare advocate to be the voice of public healthcare matters. This bill more clearly calls upon the agencies of state government to work with a healthcare advocate when making important decisions about state healthcare policy, and when appropriate, to share confidential information with the office and to allow the office to be present at meetings. In other words, to be sure they have a seat at the table. This bill and the second instant of amendment from the Healthcare Committee clarifies when state agencies shall allow the healthcare advocate access to confidential information consistent with state and federal law. Lastly, H80 clarifies what constitutes a conflict of interest to the healthcare advocate to allow healthcare advocate staff to sit on boards of nonprofit healthcare organizations as long as the primary regulator for that provider is not an agency in the state of Vermont. The committee heard testimony from Public Health Policy Director from the Agency of Human Services, General Counsel from the Green Mountain Care Board, Staff Attorney, Office of the Healthcare Advocate from Vermont Legal Aid, Deputy Commissioner of Insurance, the Department of Financial Regulation, Deputy Chief Counsel, Office of the Legislative Counsel, Vice President of Government Affairs at MVP Healthcare, Chief Healthcare Advocate from Vermont Legal Aid, Staff Attorney at the Agency of Human Services, and the Director of Government, Public and Media Relations with Blue Cross Blue Shield. Committee vote, as I said, was 10-0-1 in favor. We kindly ask for your support.
Now, the member from Essex, Representative Black, and others offer an amendment to the report of the Committee on Healthcare that is printed in today's calendar. Member from Essex.
Thank you, Madam Speaker. I'll just say that your chair of House Healthcare learned an awful lot in her very first crossover week. And the most important thing I learned was never send stakeholders, lawyers into a room to hammer out language without ensuring that our legislative counsel is also present. You end up with terms such as, oh my goodness, articulatable, I said it wrong, articulatable nexus. We sent them back into a room, and over the weekend, they came up with language that your chair can actually enunciate. So we are amending the first instance of amendment by replacing with a substantial relationship to the rate filing and review criteria rather than articulatable nexus. It has the same meaning, and I can say it. Probably because we were in maybe an inarticulatable vortex or maybe a matrix, I'm not sure what it was. As we were walking through the bill in final markup, we actually also missed a word that we intended to remove from the underlying bill. So amending section 1B of the underlying bill, we're removing the word contemporaneously. It's had read the Green Mountain Care Board shall post contemporaneously on its website. It was felt that that could be interpreted that they would have to post in the exact moment that they received the information. We've just removed contemporaneously. And that is the instances of amendment.
Member from Colchester.
So we did hear from legal counsel and all members of the healthcare committee and the co-sponsors of this amendment. And we found that the amendment favorable on a straw poll vote of 11-0-0.
The question is, shall the report of the Committee on Healthcare be amended as offered by the member from Essex and others? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have amended the report of the Committee on Healthcare. Now the question is, shall the bill be amended as recommended by the Committee on Healthcare as amended? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have amended the bill. Now the question is, shall the bill be read a third time? Are you ready for that question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and third reading is ordered. Next is House Bill 209, which is an act relating to intranasal epinephrine, in schools. Oh dear. The bill was referred to the Committee on Education, which recommends that the bill be amended as printed in today's calendar. The member from Glover, Representative Harple, will speak for the committee. Please listen to the second reading of the bill.
H209, an act relating to intranasal epinephrine in schools.
Member from Glover.
Thank you, Madam Speaker. May I speak to the underlying bill as well as an amendment?
You may.
H209 is an act relating to intranasal epinephrine in schools. If you'd like to follow along, it is on page 713. This bill accomplishes two outcomes. It allows the use of a new intranasal delivery system of epinephrine and better clarifies language to indicate that school nurses are in charge of authorizing school personnel to administer medication such as epinephrine. I will now walk you through the language in this bill. Subdivision 1 adds a licensed practical nurse to the list of school employees who can be authorized to administer epinephrine. It further clarifies that it is a school nurse who is the only person who can authorize others to provide epinephrine. Subdivision number 4 defines intranasal epinephrine, which is a way of taking it in your nose. Subdivision number 7 defines what a school nurse is. The rest of the bill adds the term intranasal epinephrine where appropriate. The effective date that this would go would be July 1st, 2025, which gives schools much needed information and predictability for planning for next school year. In taking testimony on H209, witnesses included the bill's sponsor, legislative counsel, a school nurse from the Westminster School, and the president of the Vermont State School Nurse Association. The committee vote was 11-0-0, and we ask for the body's support.
The question is, shall the bill be amended as recommended by the Committee on Education? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have amended the bill. Now the question is, shall the bill be read a third time? Are you ready for that question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and third reading is ordered. Up next is House Bill 219, which is an act relating to creating a family support pilot program for incarcerated parents and guardians. The bill was referred to the Committee on Corrections and Institutions, which recommends that the bill be amended as printed in today's calendar. The member from Shelburne, Representative Sweeney, will speak for the committee. In carrying an appropriation, the bill was then referred to the Committee on Appropriations, which recommends that the report of the Committee on Corrections and Institutions be amended as printed in today's calendar. The member from Underhill, Representative Squirrel, will speak for that committee. Please listen to the second reading of the bill.
H219, an act relating to creating a family support pilot program for incarcerated parents and guardians.
Member from Shelburne.
Madam Speaker, H219 pertains to developing a phased-in plan to expand a program that is currently working within the Chittenden Regional Correctional Facility for women. The program's trauma-informed approach strengthens family connections, minimizes the adverse effects of incarceration, and fosters better outcomes for both parents and children. Before the Chamber is a strike-all amendment to H219 entitled An Act Relating to Creating a Family Support Pilot Program for Incarcerated Parents and Guardians. This bill proposes to create access to family support programs and services in Vermont's correctional facilities by codifying this program for both women and men. You can find the bill on page 716 of today's House calendar. Let me walk you through it. Section 1 outlines the General Assembly's intent to create access for these programs throughout Vermont's correctional facilities by 2028, accomplished through a phased implementation of the program outlined in 28 VSA, subsection 128. Section 2 of the bill amends VSA subsection 102C, which concerns the responsibilities of the Commissioner of Corrections by requiring that the Commissioner include sufficient funding of the program established under Section 128 in the Governor's proposed budget. Section 3 establishes the Department of Corrections Family Support Program in statute. Specifically, this bill establishes support to all incarcerated individuals who are parents and guardians. The program is intended to provide increased parenting knowledge and skills, planning strategies for interacting with their children, child-friendly visitation spaces, better cross-system coordination with outside agencies to deliver services to families, and support and preparation for re-entry into the community for children, parents, and guardians. Subsection 128B permits the Department of Corrections to issue grants to or contract with any nonprofit entity to support the operation of the program, which has been operating successfully for over 20 years. Subsection 128C authorizes the program to operate only to the extent funds are appropriated for its operation. We are phasing in the program in our men's facilities only as much as funds are made available. Subsection 128D creates an annual reporting requirement that mandates DOC to submit a written report to the standing committees of jurisdiction concerning the funding, participation, and outcomes of the program, and progress towards statewide implementation. Section 4 of the bill concerns the initial implementation of the program, which would occur at the Chittenden Regional Correctional Facility for women and the Northern State Correctional Facility for men. Section 5 of the bill outlines the appropriation to each facility, specifically $115,424, which is filling in the funding gap at the women's facility, is appropriated from the general fund to DOC to support the program at Chittenden Regional Correctional Facility, and $268,155 is appropriated from the general fund to DOC to establish and to support the program at Northern State Correctional Facility. Section 6 establishes the effective date for the bill of July 1st, 2025, and if the bill as amended passes our chamber, it will be renamed an act relating to establishing the Department of Corrections Family Support Program. The Committee on Corrections and Institutions heard from the following witnesses: the Commissioner, Department of Corrections, the Executive Director of Policy and Strategic Initiatives, DOC, the Commissioner, the Communications Director, DOC, the interim CEO of the Lund Center, the Director of Parent-Child Services, the Lund Center, the Kids Apart Program Coordinator, the Lund Center, and Office of Legislative Counsel. Madam Speaker, may I quote from a Kids Apart participant?
You may.
Incarceration is some of the most helpless, hopeless, and meaningless days of your life. Because of Kids Apart, I still felt like my son's mother and felt included in the parenting process, which gave me the much needed will to keep fighting. Kids Apart also gave me the means to coordinate his placement with my parents. Another major decision for my son I most likely would have never been involved with if not for this program. Soon, I was able to see my son on a schedule we could all depend on, in an environment that felt comfortable during a critical time in his development. This mother has since completed incarceration and is reunited with her young son. The bill was voted out of Committee 911. Your Committee on Corrections and Institutions respectfully asks for your support of H219.
And now speaking for the Committee on Appropriations, member from Underhill.
Thank you, Madam Speaker. H219 was referred to the Appropriations Committee because of appropriations referenced in Section 5. As a result of a discussion of H219, House Appropriations Office one instance of amendment related to Section 5. The amendment can be found on page 718 of today's calendar. In the instance of amendment, Section 5 is struck. The funding required to support the current program at the Chittenden Regional Correctional Facility and to establish a new program at Northern State Correctional Facility is currently available in the Department of Corrections FY26 budget request. The House Committee on Appropriations favorably recommends H219 as amended by the House Corrections and Institutions Committee and further amended by the House Committee on Appropriations on a vote of 11-0-0. We ask for the body's support and thank you.
Member from Shelburne.
Madam Speaker, the Committee on Corrections and Institutions sees this amendment as favorable. In a straw poll, we voted 11-0-0 in support of this amendment.
The question is, shall the report of the Committee on Corrections and Institutions be amended as recommended by the Committee on Appropriations? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have amended the report of the Committee on Corrections and Institutions. Now the question is, shall the bill be amended as recommended by the Committee on Corrections and Institutions as amended? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have amended the bill. Now the question is, shall the bill be read a third time? Are you ready for that question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and third reading is ordered. Next, members, is House Bill 244, which is an act relating to state contracting and standards for advertising. Member from Vergennes.
Thank you, Madam Speaker. Your House Committee on Government Operations and Military Affairs moves that we postpone action on H244 one legislative day.
The member from Vergennes moves that we postpone action on House Bill 244 for one legislative day. Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have postponed action on House Bill 244 for one legislative day. Next, members, we will take up House Bill 342, which is an act relating to protecting personal information of certain public servants. The bill was referred to the Committee on Commerce and Economic Development, which recommends that the bill be amended as printed in today's calendar. The member from Bradford, Representative Priestley, will speak for the committee. Please listen to the second reading of the bill.
H 342, an act relating to protecting the personal information of certain public servants.
Member from Bradford.
Madam Speaker, I'd like for each of you to take a moment of genuine reflection. Close your eyes if you feel comfortable. Picture the faces of your constituents, the young, bright eyes full of hope for the future, the weathered faces etched with the wisdom and struggles of a life lived. Think of the families barely making ends meet, worried about what tomorrow holds. Think of the strong, confident individuals and those who are quietly terrified, turning to us, their elected officials, for guidance, for reassurance, for protection. They are begging us to tell them what to do. They are asking us, are you really doing everything you can? Are you speaking truth to power? Are you serving as an inspiration? Are you truly protecting us? Now imagine another scene. A Sunday afternoon, a family gathering, laughter, the scent of a home-cooked meal, a young man, just 20 years old, full of life, full of promise, celebrating his birthday with the people he loves most in the world, a son, a protector, a future tragically cut short. That day in July 2020, a knock came at the door of a home, the home of a federal judge in New Jersey. A knock that shattered the peace, the joy, the life of that family forever. It wasn't a delivery, it wasn't a neighbor, it was a man fueled by hate, a self-proclaimed anti-feminist lawyer, a man who had found the judge's address online. He had come to murder her. He had hunted her like an animal, using the tools that big tech, in their insatiable greed, had placed in his hands. That judge's son, that bright, promising young man, her only child, opened the door. He stood in the doorway, a shield between his parents and the darkness that had come to claim them. He was shot, murdered in his home, a home that should have been a sanctuary, a place of safety, a place of love. His father, rushing to his son's side, was gravely wounded, shot 3 times. He lives but carries the scars, both physical and emotional, of that horrific day. The judge, by sheer chance, survived, but she lives with the unbearable weight of a mother's grief. She lives with the knowledge that the very system she dedicated her life to upholding, the system of justice, of law, of protection, had been twisted, weaponized by the reckless greed of corporations that value profit over human life. This tragedy, this unspeakable loss, is not just a personal story. It's a glaring, horrifying indictment of our digital age. It exposes the brutal truth that big tech has weaponized personal information. While they peddle the illusion of connection and convenience, these unscrupulous data brokers and tech giants are profiting from selling the very information that puts our public servants, our judges, our law enforcement officers, our protectors in the crosshairs. They have built a system, a market, where home addresses, phone numbers, private details are readily available to anyone, stalkers, extremists, those consumed by hatred, those bent on violent revenge. They have created a digital hunting ground, and they are complicit in the bloodshed. They're complicit in this horrific tragedy and so many others like it. Colleagues, friends, fellow Vermonters, we started by reflecting on the faces of those we serve, those who trust us to protect them. We now must confront the stark reality of how that trust is being betrayed, how lives are being put at risk. The grief, the outrage, the injustice of that story, it must not be met with silence. It must be met with action, and action that begins today with this bill. This bill is a direct response to the dangers we've just confronted. It is a concrete step we can take right now to begin to dismantle the system that enabled this tragedy and to prevent future ones. Because today, we face a question that cuts to the very heart of that responsibility. It's a question that will define not just this legislative session, but the future of privacy, safety, and the very soul of Vermont in the digital age. The bill before us today is on its surface a narrowly tailored measure. It offers a simple yet vital option: the ability for our dedicated public servants and public safety officials, our judges, our state troopers, police officers, prison guards, investigators, victim advocates, crisis mental health workers, Human Rights Commission staff, court personnel, state's attorneys, and others who stand on the front lines of justice and democracy to shield their most sensitive personal information from being exposed to the world. But let's be clear, this bill is far more than it appears. This vote is a litmus test. It's a declaration of values. It's a line in the sand. How you vote today will send a powerful, reverberating signal, a domino effect that will shape the future of our consumer tech policy, not just in Vermont, but potentially across the nation. Many of you were here last year. You witnessed firsthand the unprecedented, relentless lobbying onslaught from big tech and big data during the debate on comprehensive data privacy bill. Over $1 million poured into this building, a tsunami of money aimed at drowning out the voices of people we represent. And I can tell you, personally, the pressure was extremely intense. The night before the failed override of the Senate, I received a direct call from a lobbyist client. They told me they had flipped 6 of our Democratic senators. They offered me a deal: betray your principles, betray the unanimous will of this House chamber, and they'd release the pressure. I refused. The override failed. And when I asked one of the senators why he yielded, his answer was chillingly simple: cowardice. That same corrosive pressure is back. The same forces that sought to undermine our efforts last year are here again, attempting to dismantle our consumer protection bills piece by piece. And I implore each and every one of you, remember that test. Remember the weight of that decision. Remember who we are here to serve. I chose to introduce this specific bill this year because it perfectly encapsulates the fundamental principles of data privacy that every Vermonter deserves. The right to choose how and when your personal information is disclosed, choice, a fundamental American value. The right to legal recourse when you are wronged, justice, the bedrock of our legal system. The right to tools to navigate the murky world of data brokers and entities that profit from selling your information, often without your knowledge or consent. Transparency, the foundation of a fair marketplace. Vermont prides itself on being a pioneer, creating the nation's first data broker registry. We recognize that there's a spectrum. Some data brokers play a helpful role respecting privacy requests, but others treat Vermonters like commodities, their personal information a mere product to be sold, bought and sold, with zero regard for the consequences. And let's be absolutely clear about the consequences. If we fail to act, if we do not move forward with this bill, we are sending a clear message to big tech. Vermont is open for manipulation. We are signaling that we can be pressured, that our principles are negotiable, and that signal will embolden them to undermine every future privacy bill, every attempt to regulate artificial intelligence, every effort to protect our citizens in the digital age. This is a slippery slope. Some may say it can't happen here. They may cling to the parochial belief that Vermont is somehow immune to the dangers of the digital world. That is a dangerous delusion. The internet knows no boundaries. Big tech's reckless disregard for privacy has created a nationwide crisis, and we are not exempt. Every day we delay is another day our public servants are needlessly exposed. Public officials across this state have faced threats. These threats often go unreported because the targets fear further exposure. Don't let silence mask reality. H342 can be found on page 854 of today's calendar. Section 1, Findings and Purpose. This section establishes the legislative findings and the overall purpose of the bill. It highlights 3 key points. 1, the essential role of public servants. The General Assembly recognizes the critical role that judges, prosecutors, law enforcement officers, and other public servants play in the functioning of Vermont's government. It acknowledges the inherent danger these individuals face due to the nature of their duties. 2, the rising threat and misuse of information. The legislature finds that violence and intimidation against these public servants and their families are increasing, and that public access to their personal information is being used to facilitate these threats. It emphasizes that this personal information has negligible value to the public interest. The necessity of protection. Based on these findings, the section concludes that the provisions of this bill are necessary and appropriate to protect the privacy, safety, and security of public servants and to prevent interference with the administration of justice and government operations. This sets a strong foundation for the bill's purpose: protection, not obstruction. Section 2, 9 VSA Chapter 62 is amended to read Chapter 62, Protection of Personal Information, Subchapter 5, Data Brokers, Section 2448, Non-Disclosure of Certain Public Servant Personal Information. This section adds a new section, Section 2448, to Vermont's existing data broker law, 9 VSA Chapter 62, Subchapter 5. This new section is the core of the bill, establishing the right to non-disclosure and the mechanisms for exercising that right. A is from myself. Definitions, this subsection defines key terms used throughout the new section. Understanding these definitions is crucial for interpreting the scope and effect of the bill. The most important definitions are assignee. It allows a covered person to assign their rights to bring a civil action to another person or entity. Authorized agent, a broad definition which empowers someone to submit or revoke requests on behalf of a covered person, including a designated trustee or agent, legal guardian, or someone appointed in a notarized document. Covered person, this defines who is eligible for the protections offered by the bill. It includes a wide range of individuals, including active or former judges, law enforcement officers, both state and federal, prosecutors, public defenders, parole and probation officers, and members of the Vermont Parole Board. It also includes employees of several key state departments, Family Services Division of DCF, Human Rights Commission, Department of Corrections, Department of Public Safety, including the state police, Department of State's attorneys and sheriffs and all state courts, investigators, victim advocates, mental health crisis workers, and embedded crisis specialists working for any of the listed entities. Importantly, it also includes the immediate family of all of the individuals listed. Data broker, this adopts the existing definition from 9 VSA Section 2430, but excludes governmental agencies and their representatives acting in their official capacities. This clarifies that the bill targets the private sector, not government operations. Disclose, disclosing, or disclosure. This is a very broad definition encompassing virtually any form of making information available to others, including selling, giving, lending, posting, publishing, or even including it in a searchable list. The only exception is maintaining the information completely inaccessible and unviewable to anyone outside the organization. The broad definition is key to the bill's effectiveness in preventing the spread of protected information. Federal law enforcement officer uses the definition from federal law 18 USC section 115 C1, but limits it to those working or residing in Vermont. Home address includes a partial or complete street address or any information that reveals a home's location, such as tax, parcel ID, legal property description, or geographic coordinates. The home telephone number is a broad definition that includes any number, including mobile or personal communication. Immediate family uses the definition from 3 VSA section 1201, which includes spouses, children, parents, siblings, and other close relatives. Judge includes any justice, judge, or magistrate of a Vermont state court or a federal court located in Vermont, or any person who serves as such in another state who lives in Vermont. Law enforcement officer uses the definition from 20 VSA section 2351A, which is a broad definition encompassing various types of law enforcement personnel. Parole and probation officer includes corrections services specialists employed by the Department of Corrections and parole or probation officers employed by a Vermont county or municipality. Prosecutor includes Vermont state's attorneys or deputy state's attorneys, the Attorney General or an Assistant Attorney General, or a U.S. Attorney General or Assistant U.S. Attorney working in Vermont. Protected information, this defines what information is covered by the bill. It includes home address, both primary and secondary residences, home telephone number, personal email address, social security number or driver's license, license plate number, or other unique vehicle identifiers. Public defender includes a range of public defenders as defined in 13 VSA Chapter 163. Non-disclosure of protected information. This subsection establishes the core right and the process for exercising it. The right to request non-disclosure. A covered person or their authorized agent has the right to send a notice to a data broker requesting that the data broker cease disclosing or redisclosing their protected information. This is the heart of the bill. The data broker's obligation. Upon receiving such a notice, the data broker must cease disclosing the protected information within 15 days and must not disclose it after that time. This creates a clear, enforceable obligation. Form of notice. The Secretary of State will provide a standard form for the notice, but no prior verification of the covered person's status is required. This simplifies the process for covered individuals. Until the form is published, within 90 days of July 1st, 2025, covered persons can use their own written notice referencing the law. Remedies. This subsection outlines the consequences for data brokers who violate the non-disclosure requirement. Tiered enforcement. There are 2 tiers of remedies, depending on how long after receiving the notice the violation occurs. 15-day violation. If a data broker discloses protected information more than 15 days after receiving notice, the covered person or their assignee can bring a civil action in the Superior Court for an injunction, which means a court order to stop the disclosure. The 30-day violation. If a data broker discloses protected information more than 30 days after receiving the notice, the covered person or their assignee can bring a civil action for damages, the greater or actual damages or liquidated damages of $1,000 per violation. Punitive damages, if the violation was willful or reckless, and attorney's fees and costs to make it feasible for individuals to enforce their rights. Other equitable relief, any other relief the court deems appropriate. Standard of fault. The standard of fault for any judicial proceeding is ordinary negligence. This means the covered person does not need to prove intent or recklessness, only that the data broker failed to exercise reasonable care. Importantly, it is not a defense that the information was available from other sources. This closes a potential loophole. Accessing information. This subsection clarifies that a covered person or their authorized agent accessing a data broker's website to check for the disclosure does not automatically agree to any of the website terms and conditions that would waive their rights under this section. This prevents data brokers from using sneaky website terms to undermine the law. Limitations. This subsection clarifies that some important limitations on the scope of the bill. Authorized disclosures. A disclosure is not a violation if it was made with the express authorization of the covered person given after the non-disclosure request. This allows for legitimate transactions where the covered person wants their information shared. It's made for the sole purpose of facilitating a transaction initiated by the covered person. This again allows for necessary disclosures in everyday life. Non-applicability to authorized disclosures. This section does not apply to a data broker when they are covered by subsection 1 in this section. No prohibition on employer disclosures to Labor Relations Board. This bill does not prevent employers from providing employee information to the Vermont Labor Relations Board or employee organizations as required by law. No deletion requirement. Crucially, this bill does not require data brokers to delete protected information, only to cease disclosing it. This addresses a common concern raised. Section 3, delayed start for certain remedies. This section delays the effective date of the stronger remedies damages, punitive damages, attorney's fees under 9 VSA Section 2448C1B until January 1, 2026. This gives data brokers a grace period to come into compliance before facing financial penalties. However, the right to seek an injunction is available immediately upon the bill's effective date, July 1, 2025. Section 4, the effective date. This section sets the effective date of the act as July 1st, 2025. Now, let's be clear about precisely what this bill does and, just as importantly, what it does not do. What this bill does. This bill, at its core, is about empowerment. It provides our dedicated public servants and public safety officials, the judges, law enforcement officers, prosecutors, victim advocates, and others who serve on the front lines of our justice system with a critical tool, the right to request the non-disclosure of their most sensitive personal information, such as their home addresses. This is not about blanket secrecy. It's about giving these individuals control over who has access to information that could put them and their families at risk. This bill creates a pathway to privacy. It establishes a clear, actionable process for these individuals to make those non-disclosure requests to data brokers, entities that often operate in the shadows, collecting and selling personal information without direct consent. It provides a mechanism for them to say, my safety matters and I choose to protect it. This bill is about choice. The covered person can always provide authorization to waive non-disclosure. This bill allows individuals to choose who they receive solicitations from, protecting their privacy without hindering legitimate fundraising efforts. This bill builds upon Vermont's long and proud history of prioritizing privacy protections. In the absence of comprehensive federal or Vermont data privacy laws, we have a duty, a moral obligation, to take these incremental yet vital steps to protect our own, especially those who dedicate their lives to protecting us. What this bill does not do, this bill does not in any way hinder law enforcement investigations or cooperation with legal processes. It explicitly excludes any interference with civil, criminal, or regulatory investigations, subpoenas, or summonses from any governmental authority. This is not about obstructing justice. It's about protecting those who uphold justice. This bill does not apply to federal, state, tribal, or local government entities operating within their ordinary course of operation. This is about regulating the private sector, the data brokers who profit from selling personal information, not about restricting the legitimate functions of government. This bill does not prevent covered individuals from obtaining mortgages, credit, running background checks, or engaging in other essential transactions. It explicitly allows for the disclosure of protected information with the authorization of the covered person. If a judge wants to buy a house, or if an employer needs to run a background check on a potential hire, they simply obtain authorization, just as they would under current law. Claims that this will disrupt real estate transactions or hiring processes are simply untrue. The concern that this bill would prevent car manufacturers from sending recall notices is unfounded. This bill does not impose unreasonable compliance costs on businesses. Over 80 million Americans are already covered by state privacy laws, and responsible companies are already investing in data privacy compliance. This bill covers a relatively small, targeted population of Vermont's public servants and public safety officials. This is a crucial point. This bill does not require the deletion of any data. It solely focuses on non-disclosure. Data brokers can retain and use the information internally. They simply cannot sell or share it with third parties without the covered person's consent. This is important to reiterate. This bill isn't designed to stop the collection of data. It's designed to provide an opportunity for a population of Vermonters who risk their lives for our protection to have privacy if they request it. This is a narrowly tailored, carefully crafted bill designed to address a specific and urgent need. It is a non-disclosure bill, giving rights to a critical population of Vermonters, those that protect the most vulnerable, to protect themselves. As other states move forward with similar protections, we must ensure that Vermonters are not left behind. We must ensure that those who serve us are not forced to sacrifice their safety and the safety of their families. I implore you, colleagues, stand with me, stand with our public servants, stand with our public safety officials, stand against the insidious influence of big tech, their lobbyists, and their relentless pursuit of profit at the expense of human safety. Learn from the tragic loss of a judge's son. Let his memory be a call to action. Let it be the catalyst for a fundamental shift in how we treat personal information. This is not just about this bill. This is about the future. This is about reclaiming control. This is about demanding accountability. This is about building a movement that starts here, in this chamber, today, and spreads across the nation, demanding an end to the appalling practice of profiting from jeopardizing lives. This is our chance to show the world that Vermont will not be bullied. Vermont will not be bought. Vermont will protect its own. Let's make this my and our most powerful statement yet. Let us inspire a generation to take this fight forward. We heard testimony from the following: the Chair, House Committee on Judiciary; Sponsor, House Committee on Commerce and Economic Development; President of the Vermont Bankers Association; Privacy Researcher from Obscure IQ; Director of Government Relations from the Consumer Data Industry Association; Data Privacy and Emerging Technology Expert, Founder of Debbie Reynolds Consulting LLC; Senior Operations Counsel of the First American Title Insurance Corporation; McConaughey and Reisman, Professor of Law, Florida State University College of Law; Founder of Global Cyber Strategies; the Executive Director of the Coalition for Sensible Public Records Access; the CEO of Atlas Data Privacy; the Attorney General; Legislative Counsel, Office of Legislative Counsel. The bill passed out of committee favorable on a vote of 7-4-0. Your Committee on Commerce and Economic Development respectfully requests your support on this bill.
The question is, shall the bill be amended as recommended by the Committee on Commerce and Economic Development? Member from Castleton.
Thank you, Madam Speaker. Madam Speaker, I want to begin by painting a picture as well. Private jets flying from state to state, special interest groups shuttling teams into meeting rooms to create vast amounts of wealth for their clients and their investors. One might assume the parties I'm referring to are the titans of Wall Street, or maybe the tech moguls from Silicon Valley. But in reality, Madam Speaker, the clients I speak of are the supporters of H342, and the meeting rooms they frequent are right here in Montpelier. Let me be clear. You will not find a more vocal advocate for law enforcement and the individuals covered in this bill than myself. This legislation was presented to the Committee on Judiciary as a law enforcement protection bill. It was later referred to the Committee on Commerce and Economic Development, where it was characterized as a consumer protection measure. The reality, it accomplishes neither. There is no doubt that the tragedy that happened in New Jersey is heartbreaking. Passing this bill, Madam Speaker, will create a new industry in Vermont. No, I'm not referring to a new industry of technology or agriculture, but rather an unwelcomed industry where powerful law firms fly into our state and capitalize on the very people they say they are here to protect. They will line their pockets and they will leave, leaving havoc in their wake. A well-crafted bill should aim to prevent the public dissemination of personal information that could lead to the harassment or harm of our public servants. The focus should be a comprehensive protection, not just regulating a single business model while leaving massive loopholes that render the bill ineffective. The flaws in this bill as it currently stands are numerous, but for starters, it only applies to data brokers. This ignores the fact that many of the largest collectors and disseminators of personal data, like Google, are not classified as data brokers under Vermont law. Under Vermont's current definition of data broker, it casts a very wide net. Small municipalities, like my hometown of Castleton, could be one. Tried and true brands like John Deere and Carhartt could be characterized as such. It exempts state agencies, the very agencies employing the protected individuals, such as our DMV, municipal offices, and courts, continue to collect and distribute this sensitive information with no restriction. It fails to prevent bad actors, Madam Speaker, from accessing this data elsewhere. If this bill were truly about safety, it would address all sources of exposure, not just a small subset of companies. Other states have successfully implemented these protections with surgical precision. The approach before us today is haphazard, it's incomplete, and it's ineffective. We need to treat all possessors of protected information equally and ensure real protection for those at risk. The Oklahoma model took a bipartisan, security-first approach that applies to any entity, private or public, that possesses protected information. It prohibits state agencies from publicly displaying personal details and establishes a clear removal and enforcement process ensuring compliance. Furthermore, the Oklahoma version clearly allows protective, routine, lawful, and beneficial uses of data consistent with the intent of the bill. This is the approach that Vermont should take and that this body should consider. Madam Speaker, I do not rise solely to point out the shortcomings of this legislation, but to offer a solution. Tomorrow, I will propose a strike-all amendment that mirrors the Oklahoma model, offering true security for those that serve our communities and our state. Today, I ask my colleagues to vote no. At this time, I would ask to interrogate the member from Bradford.
A member from Bradford is interrogated.
Madam Speaker, are data brokers the only entities that hold this type of information about public officials?
Member, no, data brokers are not the only entities that hold this information. And speaking personally, I would love to see us incorporate more, include eventually government, which we've seen at a federal level to be exposing people, in addition to plenty of other websites that are have this information. This is merely a start, and as we all know, it also goes to a second chamber if it passes here.
Madam Speaker, what I would say is I believe the due diligence should be done in this august body, and I would have grave concerns about passing on unfinished work to the Senate. My next question, Madam Speaker, is what protections exist to prevent state agencies, municipal offices, or courts from releasing the very same data?
Madam Speaker, there are protections. It depends. I guess I would say it depends on what we're talking about as far as information, and then what is covered by kind of a patchwork of sectoral data. So if you talk, examples. So for instance, healthcare has the HIPAA. Then we have Gramm-Leach-Bliley around banks and insurance. We have Fair Credit reporting agencies. So each of those have limited protections. This bill is trying to expand that for a specific population. Again, it is a start.
But Madam Speaker, I wonder, is this a law enforcement protection bill? Or is it, as it was referenced today here in your body, Madam Speaker, is this a consumer protection bill?
This is not a consumer protection bill. It actually does not fall under the Consumer Protection Act, which is one reason that the private right of action is so important for people, because they would not be covered by that. So yes, it is not a Consumer Protection Act bill. It is a non-disclosure bill for public servants, judges, public safety, in order to have their information hidden or flagged as private on different data broker registries that people can access in order to find people's home addresses.
Then I would posit, Madam Speaker, that we should stop referring to it as a consumer protection bill, which brings me to my next point of looking at the bad actors that this bill is looking to address. Would this bill do anything from these actors from retrieving protected information from publicly available sources?
Madam Speaker, may I have a moment to recess and consult with Legislative Counsel?
The House will stand in recess for a couple minutes. Will the House please come to order and members kindly take their seats? Will the House please come to order? Member from Bradford.
So the question was about publicly available information being caught in this bill. So again, this does not catch up the whole sphere of information that is on the internet. This is catching up the information that is being held by data brokers in similar things. Like during committee the other day, I paid 95 cents to be able to do background checks on all of my committee members. With their permission, I was doing this, but in order to see home addresses. And that's what we're really trying to get at.
Thank you, Madam Speaker. Continuing the line of questioning, why does this bill target one business model while allowing others to operate without restriction?
Again, this is just a start. It sounds like the member would like to expand this to additional entities. I think that's worth exploring. I would also say, given my work with other states, sometimes that is used in order to stall or kill bills from proceeding by wrapping as many entities under a definition as possible so that everyone jumps onto the fight. And I would hate for us to see us go that direction, being steered by lobbyists to do so.
And it's not, Madam Speaker, to aimlessly include relevant parties, but it is to make sure that we protect the actual individuals that this bill is seeking to do so by the consideration and passage, potential passage here in the body. Another question that I have, Madam Speaker, is shouldn't law enforcement officers, judges, and elected officials have the right to request the removal of their information across all platforms, not just a select few?
Madam Speaker, again, I would love to see us install an actual data protection bill to cover everyone, including our public safety officials, to be able to do more than what this bill tries to accomplish. This is a start.
And my last question, Madam Speaker, is when you look at covered parties that are included in this piece of legislation, why aren't jurors part of this? I hear anecdotally from my constituents and concerned members here in the body that all of us that serve on, as is our civic duty on juries, can be followed home, can be harassed, and can be, assaulted. And so I'm curious, Madam Speaker, why that wasn't one of the relevant parties that we included in this piece of legislation.
Madam Speaker, the House Committee on Judiciary heard about the need on this from public safety officials ahead of House Commerce. They gave us a list of a number of different entities and asked us to consider those for inclusion in the bill, which we did. And then our committee continued down the path of what about this person and what about this population and what about this population? And soon we were getting to an unmanageable kind of like group of entities for starting. Again, a comprehensive data privacy bill would cover everyone, but this is a start for a tailored population of people who are at the highest risk of being harmed. Jurors sounds like a great idea of a group to consider adding to this bill in the future.
As a member of the House Judiciary Committee, Madam Speaker, we did not receive testimony on whether we should include jurors or not. That is my last question. I yield back saying that it is very clear, Madam Speaker, that this bill is not ready for prime time. It's not ready to go to the Senate. And I again ask my colleagues to vote no.
The question is, shall the bill be amended as recommended by the Committee on Commerce and Economic Development? Member from South Burlington.
Madam Speaker, so the House Judiciary Committee did look at this bill. It was initially sent to our committee, and we took some extensive testimony, really looking at the need, not the solution as much. Once we got into that technical area, we really needed to send it to the committee with expertise in that area. But anyway, we did hear, I just want to read the witnesses that we heard from. We heard from the CEO of Atlas Data Privacy, Captain of the Bureau of Criminal Investigation, the legislative attorney for the Vermont Department of State's Attorneys and Sheriffs, the chief of court and judicial security of the New Jersey courts, the former director of the National Center for Judicial Security, now a security consultant, the director of the Vermont State Troopers Association, the chief of the Berlin Police Department, Legislative Council, the Defender General, and the Chief Superior Judge. And we definitely heard that this is a concern, that distribution of personal information on the internet poses a severe and growing danger to these public servants. And though they pretty consistently said this wasn't going to fully solve the problem, but this was a step in the right direction. This was going to help, and it provides some necessary protection. So that was really important. That was our mainly what we looked at. But I do want to comment about the private right of action. So these are individuals. They're judges, they're law enforcement officers, defense counsel, victim advocates, etc. But they are individuals going up against very large companies, and they are at a significant disadvantage if they have to protect their rights. And so to really enforce a right when you have a single individuals, this bill sets it up so they can assign their rights, so attorneys can gather a number of these cases or a number of these individuals and really have enough to go after these the bad actors. And not all of them are bad actors. These, from what I understand, data brokers, many will comply, but those who refuse to comply, we need an enforcement mechanism. And this bill does give that enforcement mechanism, including with the attorney's fees provision. So I do support that, and I support this bill H3042 and hope everybody will vote for it. Thank you.
Member from Northfield.
Thank you, Madam Speaker. The member from Castleton said that he would be offering an amendment tomorrow that would be based on a model from another state. If we vote no today, we can't receive or review an amendment tomorrow. And although I fear that probably will be too large in a scope to pass as a floor amendment, I would, for one, like to hear those options before the final vote. So I will definitely be voting yes today, and look forward to further debate tomorrow.
The question is, shall the bill be amended as recommended by the Committee on Commerce and Economic Development? Member from Dover.
Madam Speaker, may I interrogate the presenter of the bill?
The member from Bradford is interrogated.
Madam Speaker, if I am understanding this bill correctly, data brokers are the only businesses that are required to take action when it comes to non-disclosure requests. How many data brokers are registered with Vermont-based businesses? Addresses?
Thank you, Madam Speaker. There are, from a person who has what he claims to be the largest database of data brokers in the world at 8,600 data brokers collecting and selling our information. When I checked with him, there was only one active Vermont business in his database. There are actually 0 businesses registered as data brokers in the state of Vermont with Vermont addresses.
Thank you, Madam Speaker. Madam Speaker, we are really late on privacy. This bill is much smaller than I would like, but it is a step, and it is a really important step today when we are seeing public officials targeted over and over across multiple platforms. So I am going to urge us to take this step, and I'm going to stop there.
The question is, shall the bill be amended as recommended by the Committee on Commerce and Economic Development? Member from Burlington.
Madam Speaker, I've said this before, I think, maybe not this year. I'm having one of those moments where I'm just surprised that this is a debate. When people ask me, what's it like to do this work, I often tell them that I had to adjust my bar of disillusionment. Those moments where I realize that maybe not everybody in the room truly has the interests of Vermonters kind of first and foremost.
Member from Northfield, what is your point of order?
Madam Speaker, I believe the member is going into the area of motivations of members.
Can I see the members at the podium, please? House stand in recess. Will the House please come to order? Will the House please come to order? Member from Northfield, I find your point of order well taken and remind the member to follow the rules of the House.
I find it well taken as well. Fair point. What happens when I do this without a script? My apologies. The point I want to make is I'm surprised we're debating this. This is a no-brainer bill for me. This protects our public servants in a way that is just absolutely necessary. When I think about this bill, I think about all the testimony our committee, Corrections and Institution, has received on how difficult it is to be a probation and parole officer in this context. And this is just incredibly important legislation and has been said numerous times, it's a small step. And we have seen in this body what it's like to try and pass a more comprehensive bill. So I am just incredibly grateful for the efforts that it took to take this step. And I'm thinking about the people that this will protect. So I'm grateful for the committee for doing the work. And I guess I want to ask that when this vote is taken, that we take it by roll.
The member from Burlington requests that when the vote is taken, it be taken by roll. Is the member sustained? The member is sustained. When the vote is taken, it will be taken by roll. The question is, shall the bill be amended as recommended by the Committee on Commerce and Economic Development? Are you ready for the question? Member from Coventry.
Thank you, Madam Speaker. I think I just want to reiterate that not all data brokers are evil. There's a purpose to have data brokers. You want to buy a car, want to sell a house, buy a house, insurance. Those entities need to be able to check your background. And there's laws that cover them. We took testimony that there are laws in other jurisdictions that apply to this small group of individuals to protect their identity. And in those jurisdictions, those law enforcement officers, those judges, have gone to the data brokers. Some have complied. Others had the audacity to send cease and desist orders from their lawyers to individuals asking them to redact their information from the internet. We also took testimony that these individuals were harassed by these entities, these bad actors. There's swatting that goes on. Their name and number, internet address is given to spam operators that call them, that send email flooding their boxes, as retaliation to have the audacity for them to ask them to redact their information. That's the information, that is the testimony that we took. This is a small step to move forward. Yes, if someone wants to get your information, and if they want to do it bad enough, somehow they're going to get it. But we need to make sure that in this small step, that the data brokers are redacting that information so that a person who is upset with a judge jumps on their phone right away to find out where that judge is. If that information is not there, maybe they cool down a little bit and realize that's not such a smart idea. A small step. We also took testimony that these individuals are working with another business who wants to assist them. And they will file on their behalf with the data brokers. They will put up a firewall so the data broker can't find them and harass them. And if they don't comply, then they will go to court on their behalf. In New Jersey, this company did that for a number of individuals, went to court, spent $10 million, the first phase of it, and won. They had 5 attorneys. The data brokers had 85. That is what individuals are up against. And if we don't stand up and fight back, they're going to take over everything. We need to make sure that people, individuals, each one of us has the right to go to court and to stop this. That is what we're up against. We've crafted this bill. We heard the problems that people had. There's other jurisdictions that had 10 days where the data broker had to reply and make the fix. We changed that to 15. But after 15 days, we also gave the ability to file an injunction. So they can go to court, get an injunction. It's not suing them, it's just an injunction. The court tells them to stop. If they defy that court order, after another 15 days, then they're able to go to court and sue them. We've provided some relief from people, from individuals, from lobbyists that came to us with some problems that they saw. So I ask you, do we continue to allow data brokers, in this instance, to be able to continue to post the names, addresses, telephone numbers of our public judicial officers, the ones that save us, the ones that protect us? Are we willing to say no to that?
The question is, shall the bill be amended as recommended by the Committee on Commerce and Economic Development? Are you ready for the question? If so, member from Castleton.
Thank you, Madam Speaker. I just want to point out a couple observations that were just mentioned by my esteemed colleague. Number one, the White Knight firm that the member is describing is a multi-billion-dollar backed data privacy, data broker, third party that has taken money from people like Harvey Weinstein, billion-dollar venture capital firms like Y Combinator and Lightspeed Ventures. So I would caution the body, Madam Speaker, to be keenly aware of who we're looking up to as we think about people that are actually allegedly protecting the most vulnerable among us. The second point, Madam Speaker, and I'm going to yield back, Madam Speaker. Thank you.
Are you ready for the question? If so, will the clerk please call the roll?
Arsenault, Williston.
2 minutes. Will the House please come to order and members kindly take their seats? Will the House please come to order? I would like to remind members that we are in the middle of a roll call vote. Members and guests are prohibited from using computers, phones, or any type of an electronic device. Please refrain from the passing of notes and conversation during a roll call. And when the clerk calls your name, please answer in a loud and clear voice so the clerk can accurately record your votes. The question is, shall the bill be amended as recommended by the Committee on Commerce and Economic Development? Will the clerk please continue to call the roll?
Austin of Colchester. Bailey of Hyde Park. Bartholomew of Heartland. Bartley of Fairfax. Rebecca of Winooski. Byron of Virgins. Bishop of Colchester. Black of Essex. Bloomley of Burlington. Boslin of Westminster. Bosch of Clarendon. Boonton of Berry City. Boyden of Cambridge. Brady of Williston. Brannigan of Georgia. Brown of Richmond. Burdett of West Rutland. Burke of Brattleboro. Burkhardt of South Burlington. Burrows of West Windsor. Burt of Cabot. Campbell St. Johnsbury. Canfield of Fairhaven. Karras Duncan of Whitingham. Casey of Montpelier. Casey of Hubbardton. Chapin of East Montpelier. Charlton of Chester. Christie of Hartford. Chena of Burlington. Coffin of Cavendish. Cole of Hartford. Conlon of Cornwall. Cooper of Pownell. Corcoran of Bennington. Cordes of Bristol. Critchlow of Colchester. Damar of Venusburg. Dickinson of St. Albans Town. Dobrovich of Williamstown. Dodge of Essex. Dolan of Essex Junction. Dolgan of St. Johnsbury. Donahue Northfield. Duke of Burlington. Durfee of Shaftesbury. East of Guilford. Emmons of Springfield. Feltus of Linden. Galfetti of Berrytown. Garifano of Essex. Goldman of Rockingham. Goodnow of Brattleboro. Ghostland of Northfield. Granting of Jericho. Greer of Bennington. Gregoire of Fairfield. Hango Berkshire. Harpo of Glover. Harrison of Chittenden. Harvey of Castleton. Hedrick of Burlington. Higley of Lowell. Holcomb Norwich. Hooper Randolph. Hooper Burlington. Houghton of Essex Junction. Howard of Rutland City. Howland of Rutland Town. Hunter Manchester. James of Manchester. Kosenska of Burke. Keyser of Rutland City. Kimball of Woodstock. Kleppner Burlington. Kornheiser Brattleboro. Krasnow South Burlington. Labor of Morgan. Lowley of Shelburne. Malone of South Burlington. Lamont of Morristown. LaRush of Franklin. Lipsky of Stowe. Logan of Burlington. Long of Newfane. Luno of St. Albans City. McGuire of Rutland City. Millay of Pittsford. Marcotte of Coventry. Maslin of Thetford. McCann of Montpelier. McCoy of Pulteney. McFawn of Berrytown. McGill of Bridport. Mickless of Milton. Mahaly of Calais. Minier of South Burlington. Morganella of Milton. Morgan M. of Milton. Morse of Springfield. Morrissey of Bennington. Morrow of Weston. Rowicki of Putney. Nelson of Derby. Nielsen of Brandon. Nielsen of Brandon. Okay. Niagara of Bennington. North of Ferrisburg. Noyes of Wolcott. Nugent of South Burlington. O'Brien of Tunbridge. Odie of Burlington. Oliver of Sheldon. Olson of Starksboro. Page of Newport City. Parsons of Newberry. Pezzo of Colchester. Pincinel of Dorset. Pouch of Heinsberg. Powers of Waterford. Priestley of Bradford. Richard Pollitt. Quimby of Linden. Rachelson of Burlington. Sakowitz of Randolph. Shy of Middlebury. Sheldon of Middlebury. Sibelia of Dover. Southworth of Walden. Squirrel of Underhill. Steady of Milton. Steady of Milton. Stevens of Waterbury. Stone of Burlington. Supernut of Barnard. Sweeney of Shelburne. Taglavia of Corinth. Taylor of Milton. Tomlinson of Winooski. Toof of St. Albans Town. Torrey of Moortown. Walker of Swanton. Waz of Zachaberry City. Waters Evans of Charlotte. Wells of Brownington. White of Waitsfield. White of Bethel. Winter of Ludlow. Wood of Waterbury. Yarravoni of Morristown. Rebecca of Winooski. Bert of Cabot. Christie of Hartford. Harrison of Chittenden. Lamont of Morristown. Yes. Maslin of Thetford. McCann of Montpelier. Superdon of Barnard.
For purpose of explanation, member from Williston.
I voted in support of H 342. House Judiciary heard testimony regarding the relative necessity of this law in our state. That testimony included a former deputy state's attorney who detailed for us the experience of having her home checked for vulnerabilities after she received credible threats related to her work on behalf of the state. She described a surreal experience that included considerations ranging from a basic escape route all the way to specific strategies for staying alive as long as possible after an attack if there is no other living person in the house with her. No person should ever be put in a position that requires this particular type of education.
Member from Berry City.
Madam Speaker, I voted no today because of the outstanding concerns I expressed in committee and regarding legitimate business-to-business transactions. I am also concerned with the private right of action. I believe with additional testimony and minor changes, I could have easily supported this bill. Thank you.
Member from Jericho.
H342 is a first step in protecting our public servants. We have to start to create a way to allow our public officials to protect themselves. They should be allowed to simply ask that their sensitive information be kept private.
Member from Berkshire.
I vote yes because I'm willing to wait until third reading to make a final determination on the merits of this bill.
Member from Burlington.
Madam Speaker, I voted yes, and I look forward to future amendments from the member from Castleton and anyone else that both expand the covered sources of data and expand the classes of protected Vermonters.
Member from Milton.
Thank you, Madam Speaker. I voted no for this bill because I feel this bill provides inadequate protection for our public servants. More time must be taken to craft a bill that offers more complete protection and is fair to all parties involved.
Member from Ferrisburg.
Madam Speaker, while I agree with my seatmate that this type of legislation is absolutely necessary, I'm very disappointed that our committee could not and would not come together to compromise to achieve the full agreement needed. I truly hope that all those who voted yes today, because this is the first small step, will also vote yes tomorrow for the amendment to expand and complete it. Thank you.
Members, please listen to member from Berry Town. You may.
Madam Speaker, while this bill may be a step in the right direction, it is not comprehensive and was hastily crafted. As is true of much of the legislation I have seen in my short time here. We cannot leave this up to the other body to fix. We must and can craft fine legislation in this chamber. I look forward to the member from Castleton's amendment and hope I can vote yes tomorrow.
Member from Thetford. You may.
Maslin of Thetford.
Member from Bradford.
Madam Speaker, may I explain my vote?
You may.
I vote yes because we must ensure that those who serve and protect us are not forced to sacrifice their personal safety or that of their families.
Members, please listen to the results of your vote. Those voting yes, 99. Those voting no, 45. The ayes have it, and you have amended the bill. Now the question is, shall the bill be read a third time? Are you ready for that question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. Nay. The ayes appear to have it. The ayes do have it, and third reading is ordered. Next is Joint House Resolution 3, which is a joint resolution authorizing the Green Mountain Boys State and the Green Mountain Girls State educational programs to use the State House facilities on June 26, 2025. Will the House please come to order? This resolution has been read and appears in yesterday's journal. The question is, shall the House adopt the resolution on its part? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have adopted the resolution. Final bill on our action calendar today is House Bill 141, which is an act relating to joint fiscal year 2025 budget adjustments. Member from Essex Junction.
Madam Speaker, I move that we delay action on H141 for 2 legislative days.
The member from Essex Junction moves that we postpone action on House Bill 141 until Friday, March 21st, 2025. Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have postponed action on House Bill 141 until Friday. Members, that completes the orders of the day. Are there any announcements? Member from Burlington.
Madam Speaker, tonight is Farmers' Night. It will be a lively evening to close out St. Patrick's Day week. We will be joined by, one more time, their traditional Irish music group, a 6-piece band, so it may be a bit loud in here. There'll be guitars, fiddles, banjos, button accordions, and vocals. So hope to see you all here in the chamber at 7:30. Today is also one of the most exciting days of the year, something that may not be on your calendar, but should be from here on out. It is the member from Williston's birthday, so I hope that you'll join me in celebrating her. Thanks.
Happy birthday, member. Member from Pownell.
Madam Speaker, I have with me the House concurrent resolution celebrating the role of the manufacturing industry in the Vermont economy, which will designate April 2nd, 2025 as Manufacturing Day at the State House. It will need to be turned in tomorrow. I'd like to thank all 30 of you who have already signed on as co-sponsors and a few more senators, but I will remain in the chamber once we close here so that we can push it a little farther north. Thanks so much.
Member from Burlington.
Madam Speaker, we heard about an opportunity tonight to celebrate the music of Ireland. If you have time beforehand, I would like to invite you to come celebrate another treasure of Ireland, universal health care. Tonight, from 5 to approximately 6:30 or 7 p.m., please join us for the next meeting of the Universal Healthcare Caucus. It's going to be remote, but you could be remote from any room in this building as you wait for the Farmers' Night. And here is the agenda for our second official meeting of 2025-2026, Legislative Biennium. We're going to hear updates on current action in Vermont and review the work of your House Healthcare Committee and Senate Health and Welfare Committees. We're also going to look at what's been happening on the federal level and how that might impact policy and practices in Vermont. And then we're going to talk about possibilities for and viable actions that could be taken for advocacy on the local, state, and federal levels. And then there'll also be time for other updates and announcements. So once again, there's no in-person location. There is a Zoom meeting, and I believe I sent it out, but I can send it to you again if you didn't get it, tonight from 5 to 7. Thank you.
Member from Manchester.
Madam Speaker, the House Energy and Digital Infrastructure Committee will be meeting immediately after the floor, where our witnesses are waiting for us.
Are there any further announcements? Member from Waterbury.
Thank you. Madam Speaker, the House Human Services Committee will be meeting immediately after floor as well.
Are there any further announcements? Seeing none, member from Poultney, can you please offer us a motion to adjourn until Thursday, March 20th at 1 p.m.?
Madam Speaker, I make a motion this body stand in adjournment until Thursday, March 20th, 2025 at 1 p.m.
You have heard the motion. Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and this body stands in adjournment until tomorrow.